Business associations. Agency formation. Exists when a principal authorizes an agent to act on their behalf. The agent works for the principal's benefit and is subject to the principal's control. Principal liability for agent contracts. Agent's actions bind the principal when acting under actual or apparent authority. Actual authority can be express or implied. Express, expressly authorized by the principal. Implied, agent reasonably believes they have authority as necessary by custom or prior dealings. Apparent authority, a third person reasonably relies on the appearance of authority of the agent to bind the principal. Ratification, principal subsequently approves the agent's actions by word or actions, accepting liability. Principal liability for agent torts. Respondeat superior, vicarious liability when the agent is within the course and scope of duties on behalf of the principal. Independent contractors, not liable other than for ultra-hazardous activities and non-delegable duties. Intentional torts, for authorized actions as a natural result of duties for the benefit of the principal. Partnership, general partnership, formed when two or more parties agree to conduct business for a profit. No filing is required. Rights and duties. Unless otherwise stated in an agreement, general partners have equal rights to manage the ordinary affairs of the business and to share profits. Agent. Each partner is an agent for the partnership with authority to bind the partnership. Relations with third parties. Debts. Partners are personally liable for the debts of the partnership. Contracts. Unless otherwise stated in an agreement, each partner is an agent for the partnership with authority to bind the partnership. Liability. All partners are jointly and severally liable for all contracts and for torts within the course and scope of the partnership. New partners are not liable for debts prior to joining the partnership. However, any money paid into the partnership may be used to satisfy such debts. Outgoing partners remain liable for debts, barring release or novation. Dissociation, dissolution, and winding up. Dissociation may be voluntary or involuntary, and the partnership must buy out the dissociated partner. Dissociation terminates a partnership if there are only two partners. Dissolution occurs when a partnership stops being active and a business is wound up. Winding up is a process of paying off creditors, partners who have loaned money to the partnership, capital contributions of partners, and distribution of profits and surplus among the partners. Limited liability partnerships. Must register with state. No partner is personally liable for partnership obligations. Corporations, to shield shareholders, owners, from personal liability for corporate actions. Promoter. A promoter begins the process of incorporation. Liability. The promoter is personally liable for pre-incorporation contracts unless by prior agreement, novation, corporation adopts the contract or accepts benefits of the contract. Duties. Good faith and fair dealing with the corporation. Formation. De jure. Properly incorporated, corporate name, number of authorized shares, address of initial registered agent, and names and addresses of each incorporator, properly filed with the Secretary of State. De facto, good faith yet unsuccessful attempt to incorporate, may shield shareholders from personal liability. By estoppel, reasonable belief that a corporation exists or incorrectly holding out a business as a corporation prevents one from denying corporate status. Powers of the corporation. Ultra vires acts are acts which are outside of the corporation's stated purpose in the original filing. Debt acquisition. A corporation may borrow funds from outside sources. Piercing the corporate veil, PCV. Abuse of corporate status. Piercing the corporate veil is used to reach the assets of the shareholders. A court may pierce the corporate veil of a closely held corporation for the following: alter ego, undercapitalization, or fraud. You are not going to pierce the corporate veil of a major multinational corporation. That is not going to happen. Alter ego. Using the corporate status for personal reasons, typically lacking in corporate formalities. Undercapitalization. Inadequate funding to cover the costs of doing business. Fraud, misrepresentation. Knowingly making a false representation of material fact intended to and actually inducing a party to detrimentally rely upon it, resulting in their suffering damages. Primarily for torts, not contracts. Duties of directors and officers, corporation management. Fiduciary, good faith and fair dealing in the best interests of the corporation. Care, Act as a reasonably prudent person in good faith and fair dealing in the best interest of the corporation. Business Judgment Rule, BJR. The presumption that directors and officers will manage in good faith and fair dealing in the best interest of the corporation as a reasonably prudent person in the same or similar circumstances. I took liberty with this definition to make it easier to remember. Loyalty. Place the interests of the corporation above their own. Loyalty means avoiding conflicts of interest. Conflict of interest. Self-dealing. Entering into a contract with the corporation or having financial interest in a contract. See defenses below. Usurping corporate opportunity. May not personally act on a business opportunity without first offering it to the corporation. See defenses below. Unfair competition. May not unfairly compete with the corporation. See defenses below. Disclose. Must disclose material information relevant to the corporation required for approval. Defenses. Approval of disinterested directors, disinterested shareholders, and in fairness to the corporation. Shareholders. Shareholder suits. Direct suit awards go to the shareholder. Any derivative suit awards go to the corporation. Direct. For breach of fiduciary duty owed to the shareholder. Shareholder is suing the corporation. Derivative. On behalf of the corporation, must own stock, have standing, adequately represent the corporation, and make a demand on the directors to bring suit unless doing so would be futile. Voting agreements. No limit on duration, must be in writing, signed by all parties, and is generally non-revocable. Voting trusts. Limited to 10 years, ownership of the shares transferred to the trust, trust agreement provided to the secretary of the corporation. Controlling major shareholders' duties. Major shareholders have enough voting strength to substantially impact the corporation. They owe a fiduciary duty to the corporation and the duties of care and loyalty to minority shareholders. Watered stock. Stock issued at a price greater than market value. Instead of paying a $20,000 salary, company issues employee $60,000 of stock, a $40,000 bonus to the employee. The stock they hold is watered down. Recipient may be liable for the difference. Fundamental changes to the corporate business or structure must be approved by a majority shareholder vote. Typical procedure: board adopts a resolution, written notice to shareholders. Upon shareholder approval, articles are updated and filed with the state. Types of MAAD. Merger. Shareholder approval not required for insignificant changes. Asset sale. Sale of substantially all assets. Amendment to articles or bylaws require approval and filing with the state. Dissolution and winding up, generally like the general partnership process at the corporate level. Equitable subordination, Deep Rock Doctrine. Third-party creditors of an insolvent corporation are paid prior to shareholder creditors, due to the parent corporation's failure to properly capitalize a subsidiary. Federal securities laws. We do not need to know the statute numbers. 16B, short swing profits. Profits received within a 6-month period by a corporate insider must be disgorged to the corporation. This is for large corporations. 1. Corporation must be listed on the national exchange. 2. Corporation must have $10 million or more in assets and 2,000 plus 500 if not accredited shareholders. Corporate insiders, directors, officers in position at the time of either purchase or sale, shareholders who own more than 10% equity stock at the time of both purchase and sale. 10b-5 Insider Trading provides liability for any person trading securities based on non-public corporate information. Insider, holder of non-public corporate information. Tipper provides information. Tippee receives information. Misappropriator obtains information through other means. Fraud, misrepresentation, requires intent, material misrepresentation or omission, reliance, sale, or purchase of securities, interstate commerce, and damages. The remedy is to disgorge profits to the corporation. Civil procedure. Courts must have personal jurisdiction over the parties, subject matter jurisdiction over law and facts, be held in the proper venue, and defendants must be served with proper notice. Personal jurisdiction, PJ. Jurisdiction over the parties, specifically the defendant. Considered waived if not challenged initially. Below is how we get PJ. Traditional basis, individuals, for PJ. Party is domiciled in the state, present in the state when served notice, or by consent. Corporations, all states were incorporated, and the corporation's principal place of business, nerve center. Modernly, a proper long-arm statute allows the court to exercise personal jurisdiction over an out-of-state defendant, where the tort happened, contract entered into, advertising, etc. Minimum contacts, such that the exercise of personal jurisdiction will not offend traditional notions of fair play and substantial justice. Purposeful availment. Defendant purposely availed themselves of the benefits and protections of the state and could reasonably expect to be held in a court there. Fairness factors. Convenience to the parties, location of evidence and witnesses, judicial and state interests. Subject matter jurisdiction, SMJ. SMJ is non-waiverable. Jurisdiction over the law and facts. Federal courts are limited jurisdiction. Case must be brought by federal question or diversity. Federal question. Cause of action must arise under federal law and be stated in the initial complaint. Diversity. Different states. Complete diversity. No plaintiff or defendant on the same side of the plaintiff versus defendant equation. Complete diversity. No plaintiff and no defendant may be residents of the same state at the time when the action is commenced. It is perfectly fine to move, creating diversity, then filing a case, and that's for the MBE. Citizenship determined by natural person, domicile with intent of remaining. Corporation, states of incorporation, and location of principal place of business. Amount in controversy, greater than $75,000 at the time of filing, may be aggregated or combined. Supplemental jurisdiction, SJ. The federal court may hear additional state court claims when they arise under the same transaction or occurrence, common nucleus of operative fact, CNOF, even if the court would not have otherwise heard the claim for lack of SMJ. Same TNO and CNOF mean same facts. Venue is proper where any defendant lives if all live in the same state. Where a substantial portion of the claim occurred, tort occurred, contract entered into, etc., where a substantial portion of the property is located, or, if none of the above, where any defendant is subject to the court's personal jurisdiction, PJ. You still need diversity, though. Note, if diversity is not possible and it's not a federal question, sue them in a state court where a defendant lives. Why? State courts can hear almost any kind of case, other than non-exclusive federal claims. Proper notice, service of process, notification to the defendant of the pending action, a copy of the complaint, allowing the defendant the opportunity to be heard. Service may be made by personal service, substitute service, constructive service, registered mail, or as authorized by law. Proper notice continued on the next page with personal service. Personal service is delivered directly to the defendant. Service may be made by anyone at least 18 years old who is not a party to the action. Substitute service can be left at the defendant's usual abode, served upon anyone of suitable age and discretion who resides there, served to the defendant's authorized agent, or as permitted by state law. California. Substituted service is only allowed if personal service cannot be accomplished with reasonable diligence. Substitute service may be left at the defendant's usual abode with a competent member of the household who is at least 18 years old, and that person must be informed of the contents. Constructive service is made by registered mail, but only if the defendant agrees to waive service. California, by publication if nothing else works, plaintiff must provide affidavit after reasonable diligence to serve notice. Foreign country service, service as the court directs or in accordance with the laws of the foreign jurisdiction. Removal, defendant may remove an action to the federal court having SMJ, all defendants agree, no defendant is a resident of the form state, and removal generally sought within 30 days of complaint. Exception, defendant may not remove a case if sued in their home state when the only basis for removal is diversity. Remand, if federal court has no SMJ, the case must be remanded. Motion to remand must be within 30 days of notice of removal. Choice of law and diversity actions, Erie Doctrine. A federal court must apply state substantive law to resolve claims under state law. Court will use federal procedural law, usually regarding jury trial. Pleadings. Federal courts use notice pleading, a short and plain statement of the claim and a demand for the relief sought. In alleging fraud or mistake, a party must state with particularity the circumstances constituting fraud or mistake. Malice, intent, and knowledge may be alleged generally. California uses fact pleading. A party must state with particularity their claim and a demand for relief sought. Discovery. Parties may discover non-privileged matter which is relevant and proportional to their claim or defense. Request for physical or mental examination requires a court order upon a showing of good cause, must be related to the claim, and requested in good faith. Scope of discovery. Evidence need not be admissible if reasonably calculated to lead to the discovery of admissible evidence. California must be relevant to the subject matter involved in the action. Privileged material is not discoverable, such as attorney work product created in anticipation of litigation. Interrogatories, limited to 25 without leave of court or opposing party stipulation, cannot be served prior to the initial 26F conference, also known as the Meet and Confer Conference. Claim preclusion, res judicata. Precludes relitigation where there is a final judgment on the merits with the same plaintiff and same defendant in the prior and subsequent case. Issue preclusion, collateral estoppel. Precludes relitigation where there is a valid final judgment on the merits where the same issue was actually litigated and determined essential to the judgment. Can only be used against a party in the prior suit in the interests of fairness because they needed to have the opportunity to protect their interests. Can only be used by, traditionally, a party asserting collateral estoppel had to be a party in the previous case. Discussion of the below points is rarely, if ever, needed. These are non-mutual collateral estoppel. Non-mutual means different parties. California recognizes these. Non-mutual collateral estoppel is how the MBE addresses them. Defensive use, shield. To avoid liability in a subsequent suit will be allowed where the party against whom collateral estoppel is being asserted had a fair opportunity to be heard on the critical issue in the prior case. Offensive use, sword. To establish an issue in a subsequent suit is disfavored and will be allowed only when it is fair and equitable. Community property. General presumptions. California is a community property state. All property acquired during the marriage by either party is presumed community property. Property acquired before marriage by gift, devise, or bequest is presumed separate property. Upon divorce, community assets are divided equally, barring an agreement otherwise. Separate property remains as such. Community property is CP, separate property is SP. Quasi-community property, QCP. Property acquired while the couple was domiciled elsewhere, which would be CP if they lived in California. Quasi-community property is treated as separate property during the marriage, but treated as community property at divorce or death. Source of funds, tracing, commingled funds. For initial characterization, the burden is on the SP proponent. Property which can be traced as SP will remain as such. Property which cannot be traced to SP is considered CP. Termination of marital economic community, MEC. Expressed intent to end the marriage and conduct consistent with such intent, or if either spouse dies. They do not actually have to move out of the house, sleeping apart works. Non-married couples, unmarried cohabitants, boyfriend-girlfriend, etc. Contract law applies. Putative spouse. If a marriage is void or voidable, the party who believed in good faith the marriage was valid is a putative spouse. Property acquired during the union is called quasi-marital property, QMP. Transmutations. Changing the characterization of property from CP to SP or SP to CP is not valid unless made in writing and consented to by the adversely affected spouse. This is since 1985. Exception. Gifts between spouses of a personal nature which are not substantial in value. If you see a gift, you're going to be talking about transmutations and the gift exception. Debts and creditors. Who is liable, CP or SP? Credit acquisitions during marriage are community property debt. Rebut with intent of lender who relied solely on the borrower's separate property earnings. Timing of debts. When obligation incurred. Contract formed, tort occurred, etc. Order of debt satisfaction, where creditors can seek funds from. For community interests, community property first, then debtor-spouse separate property. For separate property interests, debtor-spouse separate property first, then community property. SP debt incurred before marriage. Debtor-spouse SP and CP are liable for debt incurred by either spouse before or during marriage. Shocking, but see the note below. The SP of non-debtor spouse is not liable for a debt incurred by the debtor spouse before or during marriage. Non-debtor spouse's income may be shielded in a separate account, not commingled and not accessible by debtor spouse. See, once you combine funds, creditors will go after the combined accounts. Exception for necessities of life, even post-separation, food, shelter, and medical expenses. Reimbursement. If CP used to satisfy premarital debt and SP is available, the CP is entitled to reimbursement. Injury damage caused by a spouse to a third party, and the actions which caused the damages had been for the benefit of the community, CP first, then SP of the tortfeasor spouse. Not for the benefit of the community, SP of tortfeasor spouse first, then CP. Personal injury recovery from a third party, we're talking about cash payments here, during marriage are community property. Death while married are community property. After permanent separation or divorce are the SP of the injured spouse. Reimbursement to community property for expenses is allowed. Personal injury caused by the other spouse. Exhaust tortfeasor spouse SP first, then CP. Presumptions inferred by title. Unless otherwise agreed that property is separate property, jointly titled property is presumed community property upon death or divorce, regardless if paid with separate property funds. This applies to any property, house, car, boat, RV, motorcycle, vacant land that has a title to it. Management and control. Fiduciary duties. Spouses contract with each other for the obligations of mutual respect, fidelity, and support. Spouses' confidential relationship imposes a duty of good faith and fair dealing. Community personal property. Equal power to manage community property. One spouse cannot gift or dispose of community personal property for less than fair value. One spouse cannot sell or convey family furnishings without written consent. Community businesses. Managing spouse can make all business decisions but must give written notice to sell. Community real estate. Statute of frauds. Statute of frauds applies. Both need to sign to sell or lease for more than 1 year. Cannot convey to a third party without the other spouse's consent. Presumed valid to a bona fide purchaser, BFP. If done, spouse can void sale within 1 year. Non-BFP can be voided at any time. At divorce. Generally, money which would have been CP will be treated as CP. If it was meant to be SP, it will be treated as SP. Use tracing the source of funds as needed. This is a general note. Most of the time, the assets are clear as to which way they are split. But if something is off the wall or difficult to discern, just write it up whichever way seems best and move on. Prenuptial agreement. Must be in writing, made voluntarily, with aid of counsel, and not be unconscionable. Must be in clear language in which party is proficient. Presented with agreement and allowed 7 calendar days to seek advice of counsel. Prenuptial agreement came up once, and it was rather obvious that although both parties agreed to it, it was not valid due to the lack of seeking counsel or allowing 7 days in which to seek counsel before signing. Constitutional law. Federal court, case or controversy requirement. Actual dispute, ripe, not moot. This is really important. Federal courts are limited to deciding actual cases or controversies. A matter is ripe when there is an actual or immediate threat of harm. If the dispute has resolved, it has become moot and the court will not hear it, barring special circumstances. It would be rare, but if you see something that could continue a harm, the court may hear it. Use the fact pattern for these. Roe v. Wade, etc. Standing. For standing, the following must be shown. An individual must have an actual injury caused by the defendant which would be satisfied by a favorable decision. Redressability. Organizational. Can sue for its own injury or on behalf of members if a member has standing, interests related to organizational purpose, and is not required to participate. State action. To violate the Constitution, there must be government involvement. By non-government party, may qualify as state action if on behalf of the government. Congressional regulation of commerce, the Commerce Clause. Congress regulates channels, instrumentalities, and people and activities which have a substantial effect on interstate commerce. If the Commerce Clause can be addressed, there is substantial effect. Negative effect of the Commerce Clause, Dormant Commerce Clause. There is no actual DCC. States must enact laws in good faith and fair dealing with other states. If they do not, the Commerce Clause would preempt state law unless it can pass strict scrutiny. The negative effect of the Commerce Clause restricts states from regulating activity affecting interstate commerce if a law is discriminatory or unduly burdensome. Discriminatory, unconstitutional unless the burden is narrowly tailored to achieve a legitimate state objective or the state is a market participant. Unduly burdensome, unconstitutional when the burden on interstate commerce is clearly excessive to the benefits to the state. Exceptions, important. Market participant, not regulation, the state owns or operates a business. DCC does not even apply. Congress allows it. Congress actually allows the regulation, typically in the law itself. Preemption, supremacy clause. Conflict preemption. Federal law preempts conflicting state law. Field preemption. When federal government occupies the entire field, states cannot regulate in that field. Necessary and proper clause. Congress has the power to make all laws which are necessary and proper to accomplish its enumerated powers. Tax and spend clause. Congress may spend for any public purpose for the general welfare. Note, due process is not an exact science. It works on a case-by-case basis, so use the fact pattern and decide if due process was valid or not. Binds federal government through the Fifth Amendment, states through the 14th Amendment. Procedural due process, PDP. Government may not deprive a person of life, liberty, or property without due process of law. At a minimum, notice and hearing. The fact pattern will give us a hint at what else should have been included. Life, kind of obvious. Liberty, physical and intangible liberties, driving, raising a family, etc. Property, real and personal property, public education, government employment, licenses, and benefits one is already receiving. Must already have the job or benefit, not merely be applying for it. Levels of scrutiny. I actually don't see a lot of depth in this area on the written, so know it generally. Strict scrutiny. Plaintiff generally wins. Government must show compelling government interest, and the law is necessary for achieving it. FAR applies to issues of fundamental rights, alienage, and race. Fundamental, marriage, living with family, childbearing and rearing, domestic travel, voting, etc. Intermediate scrutiny. Government must show law is substantially related to important government interest. GI applies to gender and illegitimacy. Rational basis test. Plaintiff generally loses. Plaintiff must show that the law is not rationally related to any legitimate purpose. AE applies to age and economic classifications. Substantive due process, SDP. Rights subject to fundamental and non-fundamental rights. Fundamental, marriage, living with family, childbearing and rearing, domestic travel, voting, etc. Strict scrutiny. Non-fundamental, age and economic regulations, rational basis. Equal Protection Clause, EPC, 14th Amendment. Prohibits the government from treating similarly situated people differently. Applicable to federal through Fifth Amendment. On its face, actually in the statute or regulation, or as applied through administration of a statute. Levels of review for EPC, what the government must prove, ways to remember it, yes, I am repeating this. Strict, necessary for compelling government interest, necessarily compelling. Intermediate, substantially related to important government interest, substantially important. Rational basis, rationally related to legitimate government interest, rationally legitimate. Takings Clause, Fifth Amendment. Private property may not be taken for public use without just compensation. Public use, rationally related to conceivable public purpose and benefit. Just compensation, market value at time of taking. Regulatory total taking, if the regulation has interfered with the owner's reasonable investment-backed expectation for the parcel as a whole, it is the taking. Permanent, physical invasion or confiscation of property, or use restriction, denying all economic beneficial use. We have to discuss this one if it comes up. Freedom of speech, content-based and content-neutral laws or regulations. Content-based law discriminates based on the substance of what it communicates. Government must show compelling government interest and the law is necessary for achieving it, strict scrutiny. Content-neutral law applies to expression without regard to substance and must be content and viewpoint neutral to meet intermediate scrutiny. Content-neutral law may be allowed if regulations are substantially related to important government interest, narrowly tailored, and leave open alternative channels of communication. Time, place, manner restrictions, TPM, must be content and viewpoint neutral to meet intermediate scrutiny. Public forums and designated public forums. Example, schools who open up meeting space for clubs. Restrictions must serve significant government interest, be narrowly tailored, and leave open alternative channels of communication. Non-public forums closed to the public. For example, airport secure areas. Must be viewpoint neutral, serve legitimate government interest, and be reasonably related. This one is rational basis. Commercial speech, intermediate scrutiny. Government must show law is substantially related to important government interest. The fact pattern would have to give us to commercial speech. Limitations on free speech regulations. Vagueness. A reasonable person would have to guess at the meaning of the law. Overbreadth. Law banning both protected and unprotected speech. Unfettered discretion. Law lacking defined standards for the denial of a permit. Prior restraints of free speech. Strict scrutiny. Government must show compelling government interest and the law is necessary for achieving it. Freedom of religion. First Amendment applicable to the states via the 14th Amendment. Free Exercise Clause bars any law which burdens the free exercise of religion. Exception. Law of general applicability which does not intentionally burden religious beliefs and advances important public interests does not violate the Free Exercise Clause. Establishment Clause. Government may not endorse or favor any specific religion. Incidentally favoring is allowable in an attempt to benefit a wide variety of people. Sect preference. Government must meet narrowly tailored strict scrutiny to achieve a compelling government interest. No sect preference. Lemon test. Law must have secular purpose, secular effect, and not foster government entanglement with religion. 10th Amendment. All powers not granted to the federal government are reserved to the states. Congress may not compel but may induce state government action by attaching conditions on federal funding. 11th Amendment. Prohibits suit against a state or state agency unless state expressly waives 11th Amendment protections, suit relates to federal law adopted under Section 5 of the 14th Amendment, the suit seeks only injunctive relief against a state or state official, or seeks money damages from a state official. Contracts and remedies. Formation. A valid contract consists of an offer, acceptance, consideration with no defenses to formation. UCC versus common law. Where a contract is for the sale of goods, movable chattel identified at the time of contract, the UCC shall govern. Contracts for services and real property are governed by common law. Merchant. One who regularly deals with this type of good, or one who holds themselves out as having special skills or knowledge regarding this type of good, pertaining to the contract. Merchant's firm offer. Under 2-205 of the UCC, a signed writing which is not revocable for lack of consideration during the time stated, a reasonable time, but in no event to exceed 3 months. Preliminary negotiations. Communications between parties prior to an offer being tendered. Mailbox rule. An offer is effective upon receipt. An acceptance is effective upon dispatch. Advertisement. Unless sufficient to invoke an acceptance, an advertisement is an invitation to deal rather than an offer. Offer. Manifestation of present contractual intent with certain indefinite terms communicated to the offeree. Terms. Q-tips. Quantity, time of performance, identity of parties, price, and subject matter. UCC only requires quantity. Counteroffer. This is a termination of the power of acceptance of the original offer and a new offer. Termination revocation. An offer is freely revocable by the offeror unless it is accepted prior to the termination revocation, the offeree detrimentally relied on the offer, or there was an option contract. Indirect revocation. An offer is deemed revoked despite direct communications between the parties if the offeree obtains reliable notice that the offeror has changed their mind. Lapse. The expiration of time stated in the offer, or, if not stated, a reasonable time thereafter. Rejection. Unequivocal non-assent to the terms of the offer. Acceptance. Unequivocal assent to the terms of the offer. Acceptance by conduct. The offeree performs an act which would be considered acceptance with the intention of accepting the offer. Accepting non-conforming goods. Non-conforming goods are an acceptance and a breach or a counteroffer. If the non-conforming goods are merely shipped, it is both an acceptance and a breach. Where a shipment is accompanied by notice that the goods are merely an accommodation and no contract is formed, it is a counteroffer. Perfect tender rule, UCC. Recipient may accept all, some, or none, returning what they do not wish to keep. Seller has right to cure if time for performance has not yet expired. Consideration. That which is bargained for and given in exchange for a return promise. Detrimental reliance. Reasonable reliance on the representations of another causing the worsening of one's position. Promissory estoppel. A promise which induces reasonable reliance may be enforced to avoid injustice. Anticipatory repudiation. Express communications repudiating a duty to perform under the terms of the contract. Demand for assurances. If reasonable grounds for insecurity of performance arise, a party may make a written demand for assurances of performance, suspending their own performance until such assurances are tendered. Failure to provide adequate assurances within a reasonable time results in anticipatory repudiation, a major breach. Breach of contract, an unjustified failure to perform an absolute duty. Major material breach excuses non-breaching party from continued performance. Minor breach. Continued performance is required. Non-breaching party may sue for defective performance. Statute of frauds. Certain types of contracts must be evidenced by a writing of sufficient detail to describe the essential terms: marriage, real estate, debt of another, 1 year, goods over $500. The following take it out of statute of frauds. Sufficient memo, a writing containing the essential terms of the agreement signed by the party to be charged. Performance. A party's performance in reliance on opposing party's oral promise for which a court may hold that the statute of frauds does not apply. Parole evidence. A writing by the parties intended to be a final agreement may not be contradicted. Integration clause. Introduction of helpful evidence may be allowed. It cannot contradict the contract. Total integration. A final writing which may not be contradicted. Partial integration. A writing which may be supplemented by consistent additional terms but may not be contradicted. Battle of the Forms. Different terms, UCC 2-207. If both parties are merchants, under the majority view, the additional terms shall become part of the contract unless the offer expressly limits the terms of the offer, the additional or different terms materially alter the offer, or the original offeror notifies the offeree that they object to the terms within a commercially reasonable time. Knockout rule. Minority rule which states that different terms knock each other out of the contract. UCC gap fillers prevail. UCC gap fillers. The UCC will imply all open terms except quantity. Dropout rule. Minority rule which states that different terms always drop out of the contract. Conditions. An act or event, the happening of which makes an absolute duty arise. Express conditions are contained in the contract. Implied constructive conditions are inferred by the express conditions. Frustration of purpose. When unforeseeable events undermine the purpose for entering into the contract, contract may be excused. Impracticability, impossibility. When circumstances change to the extent that continued performance becomes extremely impracticable, impossible, continued performance may be excused. Impracticability is subjective. Impossibility is objective. Modification. A change in terms of the original contract require mutual assent and new consideration under common law. Modernly, fair and equitable modification due to unanticipated changed circumstances of a contract which neither party has fully performed may be modified. Under the UCC, only mutual assent and good faith are required. Rescission. Termination of liability and a restoration of the parties to their former positions, extinguishing the contract. Reformation. Contract rewritten in conformity with the original intent of the parties. Misrepresentation. Knowingly making a false representation of material fact intended to and actually inducing a party to detrimentally rely upon it, resulting in their suffering damages. Unconscionability. Court may refuse to enforce the contract, limit, or strike unconscionable terms. Mistake. Mutual. No meeting of the minds. Both parties are mistaken to a basic assumption material to the contract, and the person asserting mistake did not bear the risk of mistake. The contract is voidable. Unilateral. One party knew or should have known of the mistake regarding a basic assumption material to the contract. The mistaken party may avoid the contract. General expectation damages, awarded for loss of expectation under the terms of the contract. Special consequential damages, above and beyond general expectation damages, which flow from a breach, when there is sufficient reason for the defendant to foresee those damages at the time of contract. Specific performance, equitable remedy compelling a party to perform a contract according to the agreed upon terms. Reliance damages, costs incurred by the non-breaching party in reliance on the contract. Restitution damages, quasi-contract, a remedy implied in law to prevent unjust enrichment of a benefit conferred. Avoidable consequence rule, mitigation of damages. Losses which could have been avoided by the use of reasonable means are not recoverable. Cover, substitute goods purchased on the open market for those promised but not delivered. Incidental damages, costs incurred in finding substitute performance, including costs incurred in unsuccessful attempts. Liquidated damages, a reasonable forecast of damages provided for in the contract. Lost volume sales, a seller may recover their lost profits if they have unlimited inventory and a limited customer base, even if the subject matter has been sold to another customer. Latches, equitable defense barring relief to one who has waited an unreasonable amount of time to bring a claim. Unclean hands, equitable defense barring relief to one who has engaged in bad faith related to the subject matter of the claim. Just a note here, whenever you see the defenses of latches or unclean hands, discuss the other one too. Miscellaneous contracts issues. Express warranty. Under the UCC, an express warranty is created by any of the following: an affirmation of fact or promise made by the seller to the buyer relating to the goods, a description of the goods, or a sample or model which become part of the basis for the bargain. Requirements outputs contracts. Preferred under the UCC as long as in good faith, but limits liability to reasonable demands of the other party. Good faith is consideration. Requirements contract. There is a good faith effort on the part of the buyer to have requirements. Outputs contract. There is a good faith obligation on the part of the seller to have output. Installment contract. Perfect tender rule does not apply. If a nonconformity in one or more installments substantially impairs the value of the entire contract, then the entire contract is regarded as being in breach, and the buyer can not only reject the installments, but also cancel the entire contract. Note here, you're not going to be able to cancel a substantially completed installment contract. Course of dealings, sequence of previous conduct between parties to a particular transaction, which establishes a common basis of understanding for interpreting their intentions. A long history of various dealings might work too. Pre-existing duty, a duty which one is already legally bound to perform. Implied warranty. The assurance is implied in law that the product is generally fit for normal use, UCC 2-314, and, where a seller knows of the purchaser's intended use, fitness for a particular purpose, UCC 2-315. Substantial performance. Performance of the primary, necessary terms of the agreement. Breach of warranty. Breach of an express or implied warranty relating to the title, quality, content, or conditions of goods sold. There is, in every contract for the sale of goods, a warranty that seller has good title to the goods. Bona fide purchaser, BFP. A purchaser who has, in good faith, paid valuable consideration for property without notice of prior adverse claims. Good faith purchaser. Temporary restraining order. Temporary restraining order, TRO. A 14-day emergency remedy used to maintain a status quo when a plaintiff will suffer immediate and irrevocable harm. TRO may be ex parte if immediate and irreparable injury, loss, or damage will result. Plaintiff certifies efforts made to provide notice, why notice should not be required, and provides proper security as court deems proper. TRO may be extended if good cause allows or if opposing party consents. Preliminary injunction maintains the status quo pending the outcome of an action in order to prevent irreparable harm to a party. Moving party must show likelihood of success on the merits, irreparable harm, balancing of the hardships in favor of the moving party, and there is no adequate remedy at law. These last two are rarely tested. Deck judgment was tested once. Permanent injunction, issued after a full trial on the merits, requiring the following: inadequate legal remedies, protectable personal or property interest, feasibility of enforcement, balancing of the hardship to both parties, and no valid equitable defenses. Declaratory judgment in federal court determines the rights and obligations of the parties, actual case or controversy, substantial controversy between parties having adverse legal interests, definite and concrete, to warrant declaratory relief. Criminal law and procedure. For the California bar exam, the focus is primarily on page 3, criminal procedure. Vicarious liability. Liability for the actions of another based on a relationship between the parties. Accessory. One who knows that a crime will be, is being, or has been committed and assists the principal. Unlike an accomplice, an accessory is generally not at the crime scene. Accomplice. One who aids, abets, or facilitates the commission of a crime, assists the primary party with intent that the crime be committed, liable for all foreseeable crimes committed, may be convicted even if principal is acquitted. Solicitation. When one entices, encourages, or requests another to do an unlawful act with the specific intent for the crime to be committed, merges with the completed crime, and generally there are no defenses. Attempt. A substantial act towards completion of a crime, specific intent and apparent ability beyond mere preparation toward actual perpetration of committing the intended crime, merges with the completed crime. Conspiracy. Agreement between two or more persons with specific intent to commit an unlawful act or a lawful act by unlawful means and an overt act in furthering the objective, does not merge with the completed crime. Homicide. The killing of one human being by another human being. Actual cause. But for the defendant's acts, the result would not have occurred. Proximate cause. It is foreseeable that the defendant's acts would have created the result. Murder. Unlawful homicide with malice aforethought. Malice may be demonstrated by intent to kill, intent to cause serious bodily harm, reckless and wanton disregard for the high risk to human life, depraved heart. The felony murder rule, whereby an unintentional death occurs during the commission of an inherently dangerous felony. First-degree murder. Murder committed with specific intent to kill, deliberation, and premeditation. Second-degree murder. Murder which is not murder in the first degree, can be an unintentional killing. Voluntary manslaughter. Intended unlawful homicide without malice aforethought and adequate provocation. Mitigation. Note: any and all defenses need to be looked at for mitigation. Heat of passion. Killing must have followed provocation before the defendant had the opportunity to cool off. Provocation. A reasonable person would have been provoked, and the defendant must have been provoked. The wording is because some people may not have been provoked. Cool off. A reasonable person would not have been able to cool off, and the defendant must not have cooled off. The wording is because some people may have cooled off. Involuntary manslaughter. Unintended killing without malice aforethought. Accidental homicide. Misdemeanor manslaughter. A killing without malice committed during an unlawful act not amounting to a felony. Kidnapping. Intentional moving, confining, or restraining of a person without privilege or consent. Burglary. Breaking and entering into the dwelling house of another in the nighttime with the specific intent to commit a felony therein. Modernly, transitory entry into any structure with intent to commit any crime at any time. Larceny. The trespassory taking and carrying away of the personal property of another with the specific intent to permanently deprive. Opposed to embezzlement below, typically an employee, not entrusted to employee. By trick. Obtaining possession of the personal property of another by trick or deception. False pretenses, obtaining title to personal property of another through a known false statement of material fact with intent to defraud. Embezzlement, fraudulent conversion of rightfully entrusted personal property as opposed to larceny, a manager. Robbery, trespassory taking and carrying away of the personal property of another with the specific intent to permanently deprive, in their presence and with use of force or threat of imminent bodily harm. Receiving stolen property, acquiring or controlling property known to have been stolen with the intent to permanently deprive. Insanity, MIMDI, rarely tested on written. Not-enroll, defendant does not know the nature or quality of their act or does not know that the act was wrong, legal and moral aspects, MBE term. Irresistible impulse, defendant lacks the ability to control their conduct. Model Penal Code, MPC, Due to mental disease or defect in reasoning, the defendant lacks substantial capacity to conform their conduct to the law or appreciate the wrongfulness of their conduct. Diminished capacity. An impaired mental condition short of insanity which is caused by intoxication, trauma, or disease and which prevents a person from having the mental state necessary to be held liable for a crime. Infancy. Due to age, incapacity to commit a crime, 0 to 6, rebuttable presumption, 7 to 14, or juvenile adult, over 14. Children participating in adult activities may be held to an adult standard. Intoxication, rarely tested on written. Involuntary, an affirmative defense to any criminal or negligence charge, not just specific intent. Voluntary, used to negate specific intent. Consent. Because consent was given freely, there was no crime. Defense of self. Reasonable force necessary to protect oneself up to and including the use of deadly force. Defense of others. Reasonable force necessary to protect others with whom the defendant has a special relationship up to and including the use of deadly force. Defense of property. Reasonable non-deadly force necessary to protect one's chattel. Necessity. A person is privileged to enter the land or interfere with the chattels of another if it is necessary to protect a person from death or serious bodily harm. Protection of more than two others is an absolute defense. Less makes defendant liable for damages. This page is the most often tested material on the written exam for criminal law and procedure. Lawful arrest requires probable cause or reasonable belief that the person committed a crime. Valid search warrant, affidavit, must be filed in good faith based on reliable information showing probable cause, issued by a neutral magistrate, specifically state the place to be searched and the items to be seized. Search and seizure by a government agent. Search. Examination of a person's body, property, or other area where a person has a reasonable expectation of privacy. Seizure, taking possession of a person or property. Invalid search and seizure. Evidence and derivative evidence obtained in violation of the Constitution is generally excluded as fruit of the poisonous tree. 4th, 5th, or 6th Amendment violations. Exceptions include a reasonable good faith reliance on an invalid warrant, independent source, and inevitable discovery doctrines which may allow evidence to be used. Warrant exceptions. Consent. One with actual or apparent authority voluntarily consents to search, officers may search. Consent may be revoked at any time. When revoked, search must stop immediately. Plain view. An officer who is lawfully present in an area may seize an item if it is immediately apparent that the item is contraband or evidence of a crime. Exigent circumstances. Emergency situations or where evidence is about to be removed or destroyed. Search incident to lawful arrest, SILA. An officer may conduct a search of the arrestee and their wingspan during a lawful arrest. Special rules apply to arrests that occur in vehicles. Automobile, vehicle. With probable cause to believe that a vehicle contains evidence, contraband, instrumentalities, or fruits of a crime, an officer may conduct a search. Administrative. Border searches do not require a warrant if routine, reasonable, and conducted pursuant to established agency policies. Administrative was a big part of a PT. I don't really see it in the essays. Stop and frisk. Terry. Stop. Officer needs reasonable suspicion that a crime will be, is being, or has been committed. Can only stop the person briefly. Frisk. Officer needs a reasonable belief that the suspect is armed and dangerous, and the officer may only frisk for weapons. Miranda rights attached during any custodial interrogation. Custodial. A reasonable person in the same or similar circumstances would not feel free to leave. Interrogation. Questioning initiated by law enforcement or its functional equivalent. Invoking rights. Clear, unambiguous, unequivocal invocation of the right to remain silent and the right to speak with an attorney. Waiver must be made voluntarily, knowingly, and intelligently. Rare. I have seen it on MBEs. Violation of rights. While physical evidence may be admitted against a suspect, no verbal communications made after the invocation of the right to remain silent may be used against the suspect. Sixth Amendment right to counsel, offense specific. Attaches in criminal cases once formal adversarial judicial proceedings have commenced. Waiver must be made voluntarily, knowingly, and intelligently. Waiver is rare. Sixth Amendment effective assistance of counsel. To demonstrate ineffective counsel, defendant must show that counsel's performance was deficient and the result of the trial would have been different. Evidence. Relevance. Evidence must be logically and legally relevant for admission. Logical relevance, FRE, is evidence which tends to prove or disprove a material fact, and in California, evidence which is relevant to a material fact. Evidence is legally relevant when its probative value substantially outweighs the risk that it will waste time, create undue prejudice, confuse the issues, or mislead the jury. FRE 403, CEC 352. California Prop 8. The Truth in Evidence Amendment makes all evidence admissible in a criminal case, even if it is objectionable under the CEC. Exceptions to truth in evidence. I removed a number of the exceptions because they rarely came up. Defendant must open the door to their own character before prosecution can attack character. Court's power to exclude. Legally relevant above CEC 352. Hearsay. An out-of-court statement offered for the truth of the matter asserted is inadmissible unless an exemption or exception applies. Don't worry about FRE exemptions and CEC exceptions. The information is coming in. Non-hearsay. Otherwise inadmissible evidence may be admissible if being offered for some other purpose and not for the truth of matter asserted. Effect on the listener. Statements offered to establish knowledge or awareness of the listener, not for the truth of the matter stated. Prior inconsistent statements, PIS. FRE, substantively admissible if under oath and available for cross-examination. CEC, any PIS may be offered for its truth, even if not under oath. Speaker's state of mind. A statement of the declarant's then existing state of mind, emotion, sensation, or physical condition. Verbal acts of independent legal significance. Words which have a legal effect and are offered to prove such. Defamation, perjury. Party opponent admissions, FRE 801D2. Any statement made by a party may be used against them. Adoptive, a statement which the party has manifested a belief of its truth, may be silent adoption by actions. Vicarious, a statement by the party's employee, agent within the course and scope of the relationship. In California, only where negligence of an employee is the basis for liability. Co-conspirator, statements made in the course and scope of the conspiracy. Statement against interest, unavailable witness. A statement made by an unavailable declarant which is against the declarant's pecuniary, proprietary, or penal interest at the time it was made. FRE. If offered in a criminal case, there must be corroborating evidence. CEC. Also admissible if against the declarant's social interest. Must be unavailable. Dying declaration. Admissible where the statement is made while the declarant believes death was imminent and it concerns the cause or circumstances of their death. This never came up correctly. FRE. Civil and criminal homicide only. Death not required. CEC. Must be dead. Allows OJ exception for physical abuse. Present sense impression, PSI. A statement made while declarant was perceiving an event or condition or immediately thereafter. CEC, contemporaneous statement. Explaining the declarant's own conduct while engaged in that conduct. Excited utterance, CEC, spontaneous statement. A statement relating to a startling event or condition made while the declarant was under the stress of the excitement caused by the event or condition. Business records. Records kept in the course and scope of business activity, made at or near the time of the matter described, by a person with knowledge, and it is the regular practice to keep such records. Includes events, conditions, opinion, or diagnosis. CEC, events only, no opinions or diagnosis. Authentication. All non-testimonial evidence must be authenticated to prove that it is what it purports to be. The line above is all we must know. Below is how things may be authenticated. Physical evidence, through witness testimony or through unbroken chain of custody. Real evidence, distinctive characteristics, or chain of custody. Demonstrative evidence, a fair and accurate representation. Writings and recordings, admissions, eyewitness, voice, handwriting, etc. Self-authenticating documents, certified copies of public records, official publications, newspapers, and periodicals. Ancient documents, FRE, 20 years old. CEC, 30 years old. Best evidence rule. An original copy of a document is superior evidence. Secondary evidence, such as a copy or facsimile, will not be admissible if an original document exists and can be obtained. California Secondary Evidence Rule. This is California's idea of the best evidence rule. The content of a writing may be proved by otherwise admissible secondary evidence. Authentication above applies. The court shall exclude if a genuine dispute concerning material terms of the writing exists and justice requires exclusion, or admission of the secondary evidence would be unfair. Witness testimony. Personal knowledge, lay witness. A witness who has personal knowledge of the matter they will testify about, and their testimony will be helpful to the finder of fact. FRE may not be based on scientific or specialized knowledge, which would be an expert. Expert witness. Testimony is admissible if the expert has the qualified education, training, and experience, their opinion has been reached within a reasonable degree of certainty, supported by reliable principles and methods, and their testimony is helpful to the finder of fact. This covers both the Kumho-Daubert and Kelly-Frye tests. Presentation of evidence, form objection. Facts not in evidence. Question assumes facts which are not yet entered into evidence. Leading questions, direct examination. Leading questions suggest an answer. They are not generally allowed on direct, however may be used to develop preliminary matters, for youthful or forgetful witnesses, hostile witnesses, or for a witness under the control of an adverse party. Leading questions. Counsel on cross-examination can ask leading questions. Refreshed recollection, present recollection refreshed. After the witness is shown an item, they recall the facts. Inadmissible evidence may be used to refresh recollection. Opposing counsel may inspect and introduce pertinent portions into evidence. Offers to pay medical expenses are not admissible to prove liability. Under the FRE, collateral admissions of fact made during an offer to pay medical expenses are admissible, but not under the CEC. Testimony against spouse. Except as otherwise provided by statute, a married person has a privilege not to testify against their spouse in any proceeding, CEC 970. Character evidence. Generally, evidence of a person's character is not admissible to show conformity with prior acts, but is generally admissible for impeachment of credibility. Character evidence, ROS, reputation, opinion, and specific acts, also known as prior acts. Reputation, opinion, specific acts, prior acts. Reputation in the community, FRE, and CEC, okay to use. Opinion regarding a witness's opinion of the person, FRE, and CEC, okay to use. Specific acts, also known as prior acts, California criminal only. Acts engaged in by the person in question, which a witness testifies to. Prior inconsistent statements, FRE, substantively admissible if under oath and available for cross-examination. CEC, any PIS may be offered for its truth, even if not under oath. Bias and personal interest. Obvious, use the fact pattern for specifics. Impeaching with criminal conviction, prior bad acts. Must have been convicted. False statement, FRE, admissible unless over 10 years old. Felony, FRE, if defended, only if probative value outweighs prejudicial effect. Other witness, allowed unless prejudicial effect substantially outweighs probative value. CEC, admissible if not expunged, and felony involves moral turpitude. Misdemeanor, FRE, not admissible to impeach. CEC, civil, not admissible to impeach. Criminal, only for moral turpitude. Old convictions, over 10 years old. No, unless probative value substantially outweighs prejudicial effect. Rehabilitating impeached witnesses. Must meet the attack, can show witnesses good character, and prior consistent statements, PCS, may be used to rebut. Sensory deficiency, used to impeach based on the deficiency. Witness has thick glasses, hearing aid, etc. Attorney-client privilege, protects confidential communications between attorney and client for legal representation. California, this privilege does not survive the client once the settlor has closed out the client's estate. Attorney work product. FRE protects all materials prepared by an attorney or their agent in anticipation of or during litigation unless opposing counsel can show a substantial need for the materials and the information cannot be obtained without undue hardship. CEC for materials prepared by the attorney in anticipation of litigation. Absolute privilege, protection for an attorney's mental impressions, notes, or opinions. Qualified privilege, other materials prepared in anticipation of litigation are deemed as qualified work product and may be discoverable by showing a substantial need for the materials and the information cannot be obtained without undue hardship. Professional responsibility. Attorney-client relationship. arises upon agreement or by court appointment. The client's belief is determinative. Ethical duties generally. An attorney owes their clients the duties of competence, confidentiality, loyalty, and financial responsibility. An attorney owes third parties, opposing counsel, and the court the duties of candor, dignity to the profession of law, and fairness. Competence. An attorney shall represent a client with legal knowledge and skill, thoroughness, and preparation reasonably necessary for representation. In California, an attorney shall not intentionally, recklessly, or repeatedly fail to competently perform legal services. Legal knowledge and skill. An attorney who lacks the legal knowledge and skill reasonably necessary may associate or professionally consult with a competent attorney, acquire the necessary legal knowledge and skill required, or refer the client to a competent attorney. Communication. An attorney shall promptly communicate with their client with respect to informed consent, status of the matter, comply with reasonable client inquiries, and about any limitation to non-permitted representation issues. Represented parties. An attorney shall not communicate with parties known to be represented by counsel in the matter without consent or court order. Diligence. An attorney shall act with reasonable diligence and promptness in representation, and, unless representation is properly terminated, the attorney must pursue the matter to the end. Confidentiality, ABA. An attorney shall not reveal information in representation unless client gives informed express consent, there is implied authority, or as permitted by law. Attorney may reveal information in representation to the extent necessary to prevent reasonably certain death or substantial bodily harm, prevent a crime, or fraud resulting in substantial financial injury to another. California. An attorney shall make a reasonable good faith effort to dissuade the client and inform the client of attorney's ability to reveal as much information as necessary to prevent such crime. California does not recognize exception for financial injury. Loyalty. An attorney shall avoid conflicts of interest adversely affecting their client. Conflicts may occur between a client and another, a former client, or an attorney's personal interests. Current client and another. Representation materially limits loyalty to another client, former client, a third person, or the personal interests of the attorney. Former client. An attorney shall not represent a party where their interests are materially adverse to the interests of a former client in the same or substantially related matter without informed written consent. Between a client and attorney's personal interests. An attorney shall not represent a client whose position is adverse to their personal interests, unless the attorney reasonably believes that they can provide competent and diligent representation. Business transactions with clients. An attorney shall not enter into a business relationship with a client unless terms are fair, fully disclosed in writing, client is advised to seek independent counsel, and client gives informed written consent. Exception to conflicts. Two or more clients who may be adverse to each other. An attorney may represent the parties if the attorney reasonably believes they can provide competent representation, not prohibited by law, clients are not asserting claims against each other, and the clients provide informed written consent. California requires written disclosure of the conflict as well. Sexual relations with clients, ABA and California. An attorney shall not have sexual relations with a client unless a relationship existed prior to representation and a relationship does not become a conflict adverse to the client. Financial responsibility. An attorney shall represent their clients in a fair and responsible manner. This includes the representation agreement, scope of representation, contingency rules, safeguarding client documents and property, and proprietary interests. Representation agreement. Agreements shall fully disclose how all fees, costs, and expenses are calculated and scope of representation. Writing requirement. ABA and California generally. An attorney shall not make an agreement for, charge, or collect an unreasonable, illegal, or unconscionable fee. ABA, no writing required for regular fees. California, all fees over $1,000 need to be in writing unless the client is a corporation, agreement was made during an emergency, client waives the requirement in writing, or for a previous client for similar services. Fee dispute. Disperse any undisputed funds promptly, holding back disputed amount. Scope of representation. The client decides objectives of representation, to settle a matter, and in a criminal case as to plea to be entered, waive jury trial, and to testify. What to do. The attorney, in consultation with their client, determines how objectives are to be met, how to do it. Contingency rules. Fees must be in writing, signed by the client, state method by which fee is determined, including percentages in event of settlement, trial, or appeal, state expenses deducted from recovery, and whether such expenses will be deducted before or after contingent fee is calculated. California requires attorney to sign as well, and each receives a copy. California, fee is negotiable. Safeguarding documents and property. An attorney shall reasonably protect client property, keeping it separate, properly returning property and undisputed funds to the client. Proprietary interest in the cause of action or subject matter. Shall not acquire interest unless for a lien to secure fees or to contract for reasonable contingency fees. Referral fees between attorneys, ABA. Attorneys can share referral fees with other attorneys so long as the referral is to a competent attorney, client agrees in writing, and the fee is reasonable. California requires that client must consent in writing after being given a full explanation of the referral. Referral generally. An attorney shall not give anything of value to a person for recommending the attorney's services. However, a nominal gift of appreciation may be allowed. Permissive withdrawal. Allowed for any valid cause so long as it can be accomplished without material adverse effect on the interests of the client. Mandatory withdrawal. Allowed with authorization of the court if the representation will result in violation of rules of professional conduct or law, the attorney's physical or mental capacity substantially impairs ability to competently represent the client, or the client discharges the attorney. Termination, withdrawal. Upon termination or withdrawal, for any reason, an attorney shall promptly release all client materials, property, and any undisputed funds. Duties to third parties. An attorney owes third parties, opposing counsel, and the court the duties of candor, dignity to the profession of law, and fairness. Candor. An attorney must not allow the court to be misled by false statements or evidence which the attorney knows to be false. This incorporates preventing witnesses from committing perjury. Abuse of discovery. An attorney must not make frivolous discovery requests or fail to make reasonable efforts to comply with proper discovery requests. Meritorious claims. An attorney shall not bring or continue a claim or conduct a defense lacking merit. An attorney shall not pursue frivolous actions. Dignity to the profession of law. An attorney shall not engage in conduct disruptive to the profession of law. Fairness. An attorney has a general duty of fairness to third parties, opposing counsel, and the court. Prosecutors must have probable cause to proceed with the case, must disclose any exculpatory evidence, must promptly disclose new exculpatory, credible, or material evidence, must not allow extrajudicial statements to be made. Responsibilities of supervising attorney. An attorney has the duty to supervise attorneys and staff to ensure that they do not violate ethical standards. Responsibilities of a supervised attorney. An attorney being supervised is responsible for clearly unethical misconduct, even if following orders. An attorney does not violate ethical rules if they act in accordance with a supervising attorney's reasonable resolution of an arguable question of professional duty. Threat of actions. An attorney shall not threaten to present criminal, administrative, or disciplinary charges to obtain an advantage in a civil dispute. Employment of disbarred, ineligible attorney. An attorney may employ an ineligible attorney to perform research, drafting, and clerical duties which do not constitute the practice of law, with written notice given to the State Bar of Employment, a full description of the person's current bar status, lists the activities not allowed by the bar, and that the party will not perform such activities. California Rules of Professional Conduct 5.3.1. Basically, if a disbarred attorney is going to work for us in litigation support, we have to tell the bar, in writing, repeat the duties they cannot participate in, and promise that they will not. Attorney shall provide written notice to all affected clients. Attorney shall retain such data for 2 years following termination of employment with such clients. Attorney as a witness. An attorney shall not advocate in a trial in which the attorney is likely to be a witness unless the attorney's testimony relates to an uncontested matter, relates to the nature and value of legal services rendered in the matter, or the attorney has informed written consent from the client. Reporting professional misconduct, ABA. An attorney must report another attorney or judge when the attorney knows the attorney, judge, violated ethical rules that raise a substantial question as to their honesty, trustworthiness, or fitness as an attorney, judge. California, an attorney is not required to report known violations. However, an attorney must self-report for a variety of infractions. real property, joint tenancies, creation, destruction, and duties of co-tenants. Creation. The four unities for joint tenancies require tenants to acquire the same interest at the same time with title arising from the same instrument for possession of the whole property. Destruction through partition or severance. Partition. Any joint tenancy can be partitioned by voluntary agreement or judicial action. Severance turns a joint tenancy into a tenancy in common. There are four ways to do this. Give it away during life via a conveyance, sell it by signing a contract for sale, lose it via actual foreclosure, borrow against it, mortgage, in a title theory state. Co-tenants' rights and duties. Joint tenants and tenants in common have the following rights and duties. Possession of the whole property. Profits. A tenant may have to pay a co-tenant if they oust them, deplete natural resources which decreases the value of the property, or lease the property to a third party. Contribution. Each co-tenant must pay their fair share of taxes, mortgage payments, and for necessary repairs. Landlord-tenant. Tenancy in years can be week to week, month to month, or any other period of time. Tenancy in years, for any specified period of time, which expires automatically at the end of the lease. Periodic tenancy. Has no fixed date and simply continues until one party gives valid notice, must end at the end of a natural lease period, and valid notice is given one full period in advance, 1 month notice for month-to-month lease. A tenancy at will continues until either party gives reasonable notice. Duties of landlord and tenant. Tenant must pay rent. If not, landlord may evict. Forcible entry and self-help are prohibited. Landlord may sue for damages, but should seek to mitigate. Tenant must not commit waste. The fact pattern will indicate the type of waste: voluntary, permissive, or ameliorating. Ameliorating actually increases value of the property. Implied warranty of habitability. If landlord fails to deliver habitable premises, tenant may move out and terminate the lease, make repairs and offset the cost, remain and reduce or withhold rent, or sue for damages. Covenant of quiet enjoyment. Landlord must not disturb tenants in their possession or use of the premises. Constructive eviction. Tenant must show that landlord has done, or failed to do, something which has made the premises uninhabitable or unusable, give notice to the landlord, and abandon the premises within a reasonable time. Assignment and sublease. General rule, unless otherwise agreed, an interest in a lease is transferable. Assignment. Transfer of remaining interest. New tenant is liable to landlord due to privity of estate. Old tenant is also liable to landlord due to privity of contract unless the landlord allows a novation. Sublease. Transfer of less than remaining interest. New tenant is liable to the old tenant, lack of privity of estate. Old tenant is liable to the landlord, privity of contract. Non-assignment or sublease clause. Enforceable, however, courts will read these narrowly to find a waiver if possible, and if landlord accepts rent payments from new tenant, they are deemed to have waived the restriction. Real covenants. Non-possessory interest in the land, obligating the holder to either do something or refrain from doing something to the land. Plaintiff sues under a theory of breach of covenant for money damages. For benefit to run, only vertical privity is required. For burden to run, both horizontal and vertical privity are required. Privity. Horizontal between the original parties, vertical between successive parties. Real covenants require privity. Privity includes intent, notice, touch, and concern. Intent for the benefit to bind future successors, usually expressly stated. Notice to the person who the covenant is being enforced against, usually record notice. Touch and concern simply means the use or enjoyment of the land. Equitable servitude. Plaintiff sues under a theory of breach of an equitable servitude seeking an injunction. Plaintiff needs intent, notice, and touch and concern. Does not require privity. Zoning. Typically, a city changes zoning and a pre-existing business is affected. Protection of pre-existing uses. Non-conforming use. Many zoning ordinances protect or grandfather a pre-existing use. If the property is sold to a new purchaser, the pre-existing use may no longer be protected. Variance. A waiver from a zoning regulation with the showing of unique hardship. Effect on neighbors is considered. Nuisance. I force public nuisance to mimic private nuisance. Feel free to discuss safety and health issues. Public. substantial and unreasonable interference with the public's use or enjoyment of public property. Private, substantial and unreasonable interference with a person's use or enjoyment of their property. Easements, a non-possessory interest granting the right to use the land of another. A pertinent normally runs with the land automatically. Transferee must have actual, inquiry, or record notice. Engross, the personal use of another's land, generally not transferable. By prescription, as with adverse possession. The hostile, open, actual, and continuous use of the land of another for a prescribed period of time. Granting permission to use the land invalidates either type of possession. By necessity, land divided by one owner necessitates easement to access the otherwise inaccessible land. License, not an interest but a privilege to use another's land within the scope of the license. Land sale contract. Statute of frauds requirements. Writing, parties, signed by party to be bound, describes land, states consideration. Marketable title. Free and clear of all encumbrances. Basically, no one is going to sue you. Equitable conversion. Once contract is signed, buyer owns the property. Buyer is liable for loss. Remedy for breach of land sale contract. Non-breaching party may sue for damages, difference between market price and contract price. Specific performance. Court orders defendant to perform. Right to lateral and subjacent support. Adjacent soil, lateral. Underlying soil, subjacent. Lateral support. Right to lateral support is absolute. Natural state. Landowner held strictly liable if excavation causes adjacent land to subside in its natural state. You will need to address the below as well. They probably have a building on it. Improvements. Held strictly liable only if shown that land would have subsided in its natural state. Otherwise, may be liable through negligence. Requires negligence analysis from torts. Conveyance of deed. Passes legal title from grantor to grantee when legally executed and properly delivered. Requirements. Parties, in writing, signed by grantor. Description of property, words of intent, no consideration is required. A land sale contract requires statute of fraud consideration. Conveyance of a deed does not. 3 types of deeds. Quitclaim conveys actual interest of grantor with no covenants of title. General warranty warrants all defects in title and the 6 present and future covenants below. Present covenants, breached at time of sale, if at all. Season, grantor owns the property, they own it. Right to convey, grantor has the power to convey. They can sell it. Against encumbrances, no mortgages, liens, easements, or use restrictions without problems. Future covenants. Warranty of title. Grantor will defend any third-party lawful claim of title. They'll defend it. Quiet enjoyment. Grantee will not be disturbed in possession by lawful third-party claims of title. No one will sue the buyer for it. Further assurances. Grantor shall do that which is reasonably necessary to perfect title. They'll make it right. These future protections are why we buy title insurance. Special warranty deed. Grantor promises that they have not conveyed the property and it is free from encumbrances. I seriously doubt we will ever see this one. See Race Recording Act below. Delivery of deed. Requirements. Intent of present transfer of deed. Recording of the deed. Physical delivery of the deed, which is also properly delivered. Rejection of the deed defeats delivery. Title passes immediately and is not revocable. Merger doctrine. Upon closing, the deed is the operative document governing the transaction. Unless a condition of the contract is in the deed, it is discharged. Damages. Awarded for breach of covenants, if applicable. Defenses. Unclean hands, latches, and waiver. Unclean hands is bad faith. Latches is too much time. Recording acts. Ensure buyer is obtaining good title. Common law rule. First in time, first in right. 3 types of recording acts. MBE terms below are found in the MBE questions. Race. First to record wins. Very rare. Delaware, North Carolina, and Louisiana. I did not check though. Notice, BFP prevails over non-recording grantee. BFP infers without notice. Without notice thereof, unless the same be recorded according to law. MBE term. Race notice. Subsequent BFP who records first wins over grantee who did not record first. Without notice, who shall first record. MBE term. Recording acts protect bona fide purchasers and mortgagors. Bona fide purchasers take for value and without notice. Recording acts do not protect donees, heirs, and devisees who do not take for value. Recording acts apply to every instrument by which an interest in land can be created or modified. 3 types of notice. Actual. Buyer has express information of a fact. Inquiry. A reasonable person would make further inquiry. Record. Constructive. A prior interest properly recorded within the chain of title. Exception. Wild deeds do not provide constructive notice as they are not recorded in such a way that a reasonable search would disclose. Torts and Remedies. Negligence. Defendant has a duty of care owed to the plaintiff which the defendant breached, which is the actual and proximate cause of the plaintiff's damages. Duty. Standard duty of care. Conduct measured against a reasonable person under the same or similar circumstances. Duty. Special duty. Imposed by statute or case law, which may be in addition to or in place of the standard duty of care. Trespasser. Land occupier has a duty to exercise reasonable care to warn a known trespasser of artificial conditions that involve a risk of death or serious bodily harm. Attractive nuisance. Land occupier has a duty to exercise reasonable care to warn or protect children from artificial conditions that involve a risk of death or serious bodily harm. Licensee. Social guests. Land occupier has a duty to exercise reasonable care to warn the licensee of known dangerous conditions. Invitee. Customers. In addition to licensee requirements, land occupier must inspect for and repair dangerous conditions. Breach. The failure to exercise a duty of care owed to the plaintiff. Res ipsa loquitur. The thing speaks for itself. When the plaintiff's harm would not have occurred but for someone's negligence, the source of the negligence is within the scope of the duty of care owed by the defendant, and the plaintiff, or a third party, had not caused the plaintiff's harm, breach may be inferred. Causation. Plaintiff must show that the defendant is the actual and proximate cause of the plaintiff's damages. Actual cause. But for the actions of the defendant, the harm to the plaintiff would not have occurred. Thus, the defendant is the actual cause of the plaintiff's damages. Proximate cause. It is foreseeable that the actions of the defendant would cause harm to the plaintiff. Thus, the defendant is the proximate cause of the plaintiff's damages. Intervening cause. An event that comes between the initial event in a sequence and the end result, altering the natural course of events which might have connected a wrongful act to an injury. Damages. Plaintiff must show actual damages to person or property. General damages. Awarded for pain and suffering stemming from plaintiff's damages. Special damages. Awarded for all economic expenses stemming from plaintiff's damages. Medical, lost wages. Contributory negligence. Plaintiff's contribution to their own injury is a complete bar to recovery unless last clear chance. If the defendant had the last clear chance to avoid plaintiff's injury, plaintiff may recover damages. Comparative negligence. Apportions the negligence of the plaintiff and defendant accordingly. Pure comparative. Plaintiff may recover a percentage of their damages even though their negligence exceeds that of the defendant. Partial comparative. Plaintiff may be barred from recovery if their negligence equals or exceeds that of the defendant. There are 2 types of partial. This covers both. Assumption of the risk. A complete bar to recovery for a plaintiff who place themselves at risk with knowledge and acceptance thereof. Negligence per se. Statutes which create a specific duty of care so that violation of the statute may establish both duty and breach in negligence actions. Violation of a statute, ICI. Intent by the legislature to protect a class of plaintiff from a specific type of injury. Negligent infliction of emotional distress, NIED. Courts will allow a plaintiff to recover damages for emotional distress if the defendant's conduct results in physical contact or the plaintiff was in the zone of danger. Joint and several liability. Liability which may be apportioned among two or more parties. Contribution. Joint tortfeasors are required to pay their apportioned share of damages. Indemnity. A defendant who is sued and forced to pay a judgment is entitled to indemnification against a joint tortfeasor who is jointly and severally liable for causing the injury. Vicarious liability. Liability for the actions of another based on a relationship between the parties. Respondeat superior. Employer is vicariously liable for the tortious acts of their employees within the course and scope of employment and for failure to exercise reasonable care in hiring, training, and supervising their employees. Independent contractor. Generally, employers are not held responsible unless the independent contractor is involved in an inherently dangerous activity or for a non-delegable duty. Assault. Intentional placing of another in apprehension of an imminent harmful or offensive touching without privilege or consent. Battery. Intentional harmful or offensive touching of another without privilege or consent. Conversion. Intentional exercise of dominion and control over the personal property of another without privilege or consent. Defendant is liable for full market value at the time of conversion. Mention trespass to chattels if it applies. False imprisonment. Intentional unlawful physical or psychological confinement of another who is conscious of the confinement or is harmed by it without privilege or consent. Intentional infliction of emotional distress, IIED. Intentional extreme and outrageous conduct by the defendant which causes severe emotional distress in the plaintiff. Trespass to chattels. Intentional interference with the personal property of another without privilege or consent. Also mention conversion if it applies. Trespass to land. Intentional entry upon the land and possession of another without privilege or consent. Transferred intent. Liability transfers from intended plaintiff to the actual plaintiff of an unlawful act actually committed. Misrepresentation, fraud. Knowingly making a false representation of material fact intended to and actually inducing a party to detrimentally rely upon it, resulting in their suffering damages. Defense of self. Reasonable force necessary to protect oneself up to and including the use of deadly force. Defense of others. Reasonable force necessary to protect others with whom the defendant has a special relationship up to and including the use of deadly force. Modernly, to protect anyone. Defense of property. Reasonable non-deadly force necessary to protect one's chattel. Necessity. A person is privileged to enter the land or interfere with the chattels of another if it is necessary to protect a person from death or serious bodily harm. Protection of more than two others is an absolute defense. Less makes defendant liable for damages. Products liability. Manufacturers are liable to all foreseeable plaintiffs which result from a defect in the design, manufacturing, or warning of products they place in the stream of commerce. A plaintiff may seek recovery under the theories of strict products liability, implied warranty, or negligence. In products liability suits, there must be a proper plaintiff and a proper defendant. You'll simply identify them. Strict products liability applies to any harm caused by a product which is defective when it left the manufacturer, has not been altered prior to reaching the plaintiff, and is being used as intended or in a foreseeable unintended use, and the defendant is a commercial supplier routinely dealing in this type of good. Implied warranty. The assurance is implied in law that the product is generally fit for normal use, UCC 2-314, and where a seller knows of a purchaser's intended use, fitness for a particular purpose, UCC 2-315. Negligence. Defendant has a duty of care owed to the plaintiff which the defendant breached and is the actual and proximate cause of plaintiff's damages. Duty. A manufacturer has a duty to inspect for and correct defects in design, manufacturing, and warning. Breach. Failure of the product to meet the expectations of a reasonable consumer demonstrated by a defect in design, manufacturing, or warning. Res ipsa loquitur. The thing speaks for itself. When the plaintiff's harm would not have occurred but for someone's negligence, the source of the negligence is within the scope of the duty of care owed by the defendant, and the plaintiff or a third party had not caused the plaintiff's harm, breach may be inferred. Causation. Plaintiff must show that defendant is the actual and proximate cause of the plaintiff's damages. Actual cause. But for the product's defect, the plaintiff's harm would not have occurred. Thus, the defendant is the actual cause of plaintiff's damages. Proximate cause. It is foreseeable that the product's defect would cause the plaintiff's harm. Thus, the defendant is the proximate cause of plaintiff's damages. Consider intervening cause from page 1. Damages. Plaintiff must show actual damages to person or property. General damages awarded for pain and suffering stemming from plaintiff's damages. Special damages awarded for all economic expenses stemming from plaintiff's damages, medical, lost wages. Contributory negligence. Plaintiff's contribution to their own injury is a complete bodily recovery unless last clear chance. If the defendant had the last clear chance to avoid the plaintiff's injury, plaintiff may recover damages. Comparative negligence apportions the negligence of the plaintiff and defendant accordingly. Pure comparative. Plaintiff may recover a percentage of their damages even though their negligence exceeds that of the defendant. Partial comparative. Plaintiff may be barred from recovery if their negligence equals or exceeds that of the defendant. There are two types of partial. This covers both. Assumption of the risk. A complete bodily recovery for a plaintiff who placed themselves at risk with knowledge and acceptance thereof. Misuse of product, item. A party who uses a product not as intended shall not have a cause of action in product liability. Alteration of product. The alteration of a product after sale removes liability from the manufacturer. Design defect. The product was designed in such a way that it presented an undue risk of harm in normal use. There was a way to build the product safer, more practical, and at a similar cost. Manufacturing defect. The product does not conform to the manufacturer's own standards and intended design. Warning defect. Failure to warn plaintiff through inadequate instructions, warnings, labels, etc. of dangers not obvious to an ordinary user. Nuisance. I force public nuisance to mimic private nuisance. Feel free to discuss safety and health issues. Public. Substantial and unreasonable interference with the public's use or enjoyment of public property. Private. Substantial and unreasonable interference with a person's use or enjoyment of their property. Defamation. PUD. A false and defamatory assertion of fact which is published to a third person, understood as defamatory by that third person, and causes damage to the plaintiff's reputation. Spoken defamation is slander. Defamation in written form is libel. We must discuss both if it comes up, even if only one applies. Consent. Consent is a complete defense. Truth. Truth is almost a complete defense based on the scenario in the fact pattern. Privilege. Absolute or conditional. Absolute. Complete defense for official government scenarios within the course and scope of duties, and also in discussions between spouses. Conditional. Complete defense under good faith. Privilege can be lost by bad faith or abuse. Slander per se. Club. Spoken defamation regarding crimes of moral turpitude, loathsome disease, imputing unchastity of a woman or business. Injurious falsehood. False and injurious statement that discredits or detracts from the reputation of another's character, product, or business. Interference with prospective economic advantage. Intentional, damaging intrusion on another's potential business relationship, opportunity, or employment. Strict liability. Liability imposed without regard to fault. Animals. Dangerous animals. The injury must be from the dangerous propensity of the animal. Zoos and common carriers are exempt. Fleeing an otherwise non-dangerous wild animal applies. Abnormally dangerous, ultra-hazardous activities. Activities which are not a common usage in the community, and the abnormally dangerous, ultra-hazardous activity creates a highly significant risk of physical harm even when exercising reasonable care. Thin skull plaintiff, also known as eggshell skull. A defendant is liable for a plaintiff's unforeseeable and uncommon reactions to the defendant's act. You take the plaintiff as you find them. Immunity. Government units are not subject to suit unless they consent to such. See 11th Amendment below. 11th Amendment. Prohibits suit against a state or state agency unless state expressly waives 11th Amendment protections. Suit relates to federal law adopted under Section 5 of the 14th Amendment. The suit seeks only injunctive relief against a state or state official, or seeks money damages from a state official. Firefighters rule. Police and firefighters are barred from pursuing recovery against those rescued, as injury during a rescue is one of the occupational hazards of the job. An MBE note here. A cop returning to the station who is T-boned by a bad driver does have a case against them. Even though they're on duty, doesn't mean they cannot sue and collect for their injuries by negligent folks. Emergency doctrine, non-professionals. Exempts a person from the ordinary standard of care if that person acted instinctively to meet a sudden and urgent need for aid. Good Samaritan law, professionals. Exempt from liability a person such as an off-duty physician who voluntarily renders aid to another in imminent danger but negligently causes harm while rendering such aid. Nominal damages, a declaration of the plaintiff's rights and a determination that the defendant has wrongfully infringed upon them. Punitive damages, a sum of money in addition to compensatory damages to punish the defendant for willful, wanton, or malicious conduct and to deter such conduct. Balance, the measure of competing interests and appropriate offset to achieve balance. Pre-existing duty, a duty which one is already legally required to perform. Laches, equitable defense barring relief to one who has waited an unreasonable amount of time to bring a claim. Unclean hands, equitable defense barring relief to one who is engaged in bad faith related to the subject matter of the claim. Just a note here, whenever you see the defenses of laches or unclean hands, discuss the other one too. Trusts and wills. Trusts. Inter vivos means while settler is alive. A testamentary trust is created through a will. Creation and validity. Definition. Trustee holds legal title to property in a trust, managing the trust for the benefit of beneficiaries as the settler requests. Requirements for valid trust. This is what we must know. Intent and capacity. Settler must have present intent and capacity to create a trust. Precatory language is inadequate. Property, res, must be identifiable. Purpose must be legal. Beneficiary must be an ascertainable beneficiary unless it is a charitable trust or the beneficiary is at the discretion of the trustee. Trustee need not be named. Court will appoint one if need be. May be created by, not really discussed in the passing samples, but so we know. Declaration that settler, trustor, holds property as trustee. Transfer of property during settler's lifetime to a trustee. Transfer of property to a trust via a will to take effect upon settler's death. Exercise the power of appointment to another person as trustee. An enforceable promise to create a trust. Types. There are more, such as spendthrift and support, but they don't really come up on the exams. Express. Intentional transfer of property to trustee who holds legal title for the benefit of beneficiaries. Testamentary. Created via will to take effect upon settler's death, creating a trust, not a pour-over will. Pour-over. Structured to receive and dispose of assets upon settler's death, pour-over will. Charitable. Considered to be a benefit to society. See prey. If the charitable objective is no longer possible, substitute another charitable objective as closely related as possible to settler's intent. Resulting trust. If see prey is not possible, a resulting trust is formed, transferring property back to settler or their estate. Constructive. Equitable remedy for unjust enrichment, not an actual trust, gets funds to intended party. Administration. Powers of trustee. Enumerated powers expressed in the trust and, by law, implied powers necessary and proper to carry out the terms of the trust. Duties of trustee. Account. Provide the beneficiaries with an accounting of income and expenses of the trust. Care. Manage trust assets with reasonable care. Loyalty. Avoid self-dealing, avoid conflicts of interest, treat all beneficiaries equally. Impartial. Be impartial in dealings with all beneficiaries. Prudent investing. Diversify investments as a reasonably prudent investor. Uniform Prudent Investor Act, UPIA. Allows fiduciaries to utilize modern portfolio theory to guide investment decisions and requires risk versus return analysis. Defend and enforce any claims against or actions in favor of the trust. Liabilities of trustee. Personally liable for violation of duties as trustee, torts committed by trustee or agents acting within the course and scope of the trust, contracts within the course and scope of the trust unless the contract provides otherwise, modification, revocation of trust. Modern rule, settler may modify or revoke if power is expressly reserved in trust. Minority rule, California, revocable unless stated otherwise. Modification, by court, for see prey, changed circumstances, or necessity to meet settler's intent. Termination of trust, trustee, no power to terminate unless granted in the trust. Beneficiary, may compel, if all are competent, agree, and termination does not frustrate purpose. Settler, Can terminate if granted in the trust. California, revocable unless stated otherwise. Court, if purpose becomes frustrated, impossible, illegal, or for changed circumstances. Lapse, anti-lapse applies. See discussion in wills. California applies anti-lapse with representation. Remedies. Breach of trust by trustee. Damages, constructive trust, tracing, equitable lien, ratification of trust and waiver of breach, suit for resulting loss, or removal of trustee. Defenses. Latches. Equitable defense barring relief to one who has waited an unreasonable amount of time to bring a claim. Unclean hands. Equitable defense barring relief to one who is engaged in bad faith related to the subject matter of the claim. Just a note here, whenever you see the defenses of latches or unclean hands, discuss the other one too. Wills. Intestate succession frequently comes up with omitted child, spouse. Community property, CP. Survivor takes all of the community property. Separate property, SP. If decedent left no lineal descendants, survivor takes all separate property as well. Survivor takes 1/2 if the descendant left one lineal descent, 1/3 if more than one. California per capita, representation, distribution. If there is no surviving spouse, entire estate passes to the decedent's surviving issue. It goes to their kids. Per capita. Survivors take equal shares at the same generational level. If not, per capita with representation. Survivors take an equal distribution at first generational level. If any are deceased, that portion drops to the next generational level and is divided equally among takers. Testator had A, B, and C, but C predeceased T and C had 2 children, C1 and C2. They split C's share. Adopted children are included for intestate succession. Validity. Capacity and intent. Testator must know the nature of the testamentary act, nature and extent of their property, persons who are related to them, and those whose interests will be affected by the will. Execution. Formalities. To be valid, the will must be in writing, signed by the testator before 2 witnesses present at the time of testator signing who know the document is a will. Witnesses may sign later, don't have to do so at the same time, but must sign before the testator dies. Holographic. A handwritten will where the material provisions and signature are all in the testator's own handwriting. California harmless error. A will may still be probated if proponent establishes clear and convincing evidence that the testator intended the document to be their will. Interested parties. In California, there will be a presumption of duress, menace, fraud, or undue influence where a witness is an interested party unless 2 uninterested witnesses are present and sign at the time of execution. An interested witness will not be able to take more than their intestate share. See codicil republication below. Incorporation by reference. A writing in existence when the will is executed may be incorporated by reference if the language of the will manifests this intent and describes the writing sufficiently to permit its identification. California, limited tangible property. A writing referred to in the will, dated and signed by or in the handwriting of the testator, describes items and beneficiaries, no item exceeds $5,000 in value, and not total over $25,000. May be created after will execution. Codicil, supplement to an existing will to change, explain, or republish the will. Must meet the same formalities as a will or holographic will. Revocation of a codicil leaves the will valid. Revocation of a will revokes both. Republication. Validly executed codicil operates as a republication of the will. If it is a holographic codicil and dated, it resolves any issue of interested witnesses on the original will. Specifically, if all witnesses are interested parties, the will would be okayish, but they only get their intestate share. However, if the testator makes a valid holographic codicil and they date it, that clears up the issues of interested parties. Revocation. By subsequent new will. New will expressly revokes previous will or revokes previous will via inconsistencies. By physical act. Burned, torn, canceled, or obliterated with the intent to revoke by testator or at testator's instruction and in their presence. By operation of law, due to changed circumstances such as dissolution or annulment of marriage. Revival. A destroyed or revoked will is revived if the testator intends for it to be revived. Anti-lapse California. The issue of the deceased gift recipient taking their place, barring intention of testator. This only applies to bloodlines, kindred of. Issue at the same depth of relation, generation, take per capita, equally with representation. Per capita with representation. Survivors take equal distribution at first generational level. If any are deceased, that portion drops to the next generational level and is divided equally among takers. Testator had A, B, and C, but C predeceased T. C had 2 children, C1 and C2. They split C's share. Omitted child. Receives intestate share if born or adopted after the will was made, unless intentionally omitted in will, otherwise provided for, or decedent had 1 or more children and divides substantially all of the estate to the other parent of the omitted child. Share of omitted child. One who is not named in the will because they had not yet been born. California also includes a child the testator mistakenly thought was deceased or was unaware of their birth. Receives intestate share if born or adopted after the will was made unless intentionally omitted in will, otherwise provided for, or decedent had divided substantially all of the estate to the other parent of the omitted child. Undue influence. Testator has a weakness, making them susceptible to influence. The influencing party had access and opportunity to influence the testator, actively participated in drafting the will, and there was an unnatural gift. California, statutory presumption of undue influence is established if the testator makes a gift to the person who drafted the will, a care custodian, a party with a fiduciary relationship, a person who is a spouse, domestic partner, employee, or blood relative of any of the above, or a partner, shareholder, or employee of the law firm who drafted the will. Such gifts will be invalid, and the gift to a wrongdoer will lapse. Ademption. Specific gift has changed form or no longer exists. By extinction. If a specifically identified item is no longer part of the estate, the gift fails. Courts look to the testator's intent, and California favors granting an equal replacement gift from general assets. By satisfaction. A gift during the life of the testator in lieu of a testamentary gift.